Hi, everyone. Good evening. Carl Steinbeck here on this Friday night. We had a court hearing today for Donna Adelson facing her murder trial there in Tallahassee courtroom. The Honorable Judge Everett presiding, and the hearing was around an hour long. And so I'm going to cover that tonight. We'll actually just play the hearing. And so I'll just do commentary and stop it here and there for comments. Or if you guys have comments or questions, go ahead and insert those here in the chat. I prefer you do it with the red emoji. It's easier for me to distinguish a question for me versus your comments among yourselves. So I don't know if y'all got the word. I told Court TV yesterday that I wasn't interested in doing any of their shows any longer, so I will not be on Court TV anymore. So I'm supposed to be on tonight talking about this, but just going to be here on this channel talking about it from here on out. Once in a while, I'll be on another channel perhaps, but right now, no more Court TV. All right, so what I want to do is jump right to this here. We're on Law and Crime channel, and we see here Donna. They zero in on Donna right away. So let's go ahead and pick up the action here. Donna's sort of laughing there in the courtroom. That's something that Charlie did a lot. It's like they don't take this thing that serious. I don't think Donna's going to try to pull something. I think she's thinking she's going to walk, just like Charlie did. She spent a lot of money on this, and money fixes all problems. At least it has for her in the past. That's not me doing that. That's on this Law and Crime channel. So that's Josh Hellman on the right. The far left we have in the middle. See there in the middle between the three is Fulford, Attorney Fulford. And then of course we see and there's Zellman laughing. So he's jovial on whatever's being said, and Fulford is not. Wow, that's really odd. I've never seen that. Someone face first-degree murder laughing like that. Granted, it's not the jury, but
yeah.
Yeah, I just yeah, Tanya, I just didn't appreciate the way Court TV was not doing good journalism. I just didn't want to be a part of that anymore. The issues that I saw going on with Karen Reed, now I saw more issues going on in this case, and there's no point in me being on that channel anymore. Look at her laughing away.
All right, court is now set, and the Honorable Judge Stephen Everett presiding.
Morning, you see it?
Hi, Judge.
Judge Everett, sick of this Adelson fiasco. Any attorney associated with Adelson is just nothing but a pain in his side. Doesn't trust anybody associated with Adelson's. Been burned before. And he's normally cracking jokes and stuff like that, like he did at Charlie's trial when the jury isn't there, and even in front of the jury. And he may laugh at something that's funny, but he's not cracking any jokes around these guys. He knows it's a clown show he's trying to control. Yeah, she can't stand this judge. She can't stand Tallahassee. Can't stand the jurors. And she's banking on a change of venue motion being granted. She's hoping that too many people know about her case and think she's guilty, so she can get this transferred to South Florida, where more wild and crazy stuff can be.
Here this morning in State versus Donna Adelson, 2023 CF 3226. For the final pretrial hearing this morning, we're going to address all of the outstanding motions and also some matters pertaining to the trial, which is still scheduled for the selection of the jury starting on August 19th.
Yeah.
The parties can make their appearances for the record.
Georgia Kappelman for the state.
Jackie Bolton for Mrs.
They don't have Sarah there today.
Joshua Zellman for Mrs. Adelson.
I believe we have several defense motions to address. Ms. Kappelman, the state has not filed any additional motions in limine that have not already been addressed by the court.
That's correct, Your Honor.
Right. Let's start then with the motion in limine concerning the court file relating to the dissolution of marriage. Mr. Zellman.
Thank you, Your Honor. Your Honor, as is my custom, I lay it out in motion. It's our position that the vast majority of the court file, even with the court taking judicial notice, is inadmissible. It's irrelevant. Paragraph 7 of my motion provides a somewhat comprehensive list of the items that are in there that have no bearing, have no relevance, they're not material in any way to this case. And so we're asking that aside from...
It's what the whole case is about, and he knows it. That's why he's trying to keep it out. This is all about winning the custody battle that Wendy could not otherwise win, and the only way to get Wendy down there was to kill Dan, because nothing else was going to work. Wendy wasn't willing to pay $333,000 when her family was going to kick in the remaining amount to get up to $1 million. So the easier solution, the cheaper solution, was spend $100,000 and have Dan taken out. So that way you're over. It's over and done with. There's no more court battles. There's no more attorney's fees. There's no more shared custody. It's just like he's just gone. You eliminate him from the boy's life, and you change the boy's last name. And like Markel's, who's that? Who is that? Markel, that's a nothing. That's a nothing. These boys, they're 3 and 4 years old. They'll have minimal knowledge of what anything having to do with Markel is about. So that's the solution here. And it all starts in this embattled litigation going on between Wendy and Dan. And Dan was going to have some really good outcomes against Wendy and also Donna for the stunts they're trying to pull on the way the boys are being treated. So he wants to keep that stuff out, and what things that Dan was saying about Wendy's behavior and also Donna's behavior.
Very limited number of items that the state can establish has relevance, and it's not barred by hearsay. We're asking the court exclude that file.
Ms. Kappelman, which parts of this file is the state seeking to admit as a part of its case in chief?
The entirety.
And that's what they did the last time. They've admitted the entire file. So what they're doing as a defense team is here, just block everything that could hurt Donna. That's the truth. Just block it and see if the judge will find some way to go, yeah, I'll go ahead and grant that.
Right. As to the items that deal with, as identified in paragraph 7 of the motion, what exactly would be the relevance first? And what is your argument as to hearsay?
The relevance, Judge, it goes to the motive, the level of intensity of this litigation, the volume of the paperwork suggests that it was very litigious and went on for some time. The words that are used are strong, even hateful, and this was a cause that was adopted by the defendant, as the emails evidence will show. So it's important for the jury to understand the foundation of this motive is this litigation that began with the divorce, continued beyond the divorce with the child custody issues that develop later.
All right.
I would say this is the thing that escalated to the plot to murder Dan Markel, because they were losing bad and they had some motions where she was being held in contempt. Dan was referencing her losing her job, potentially not being fit for duty to serve as a adjunct professor at FSU Law School. So he was dropping the hammer on stuff she was doing and assets she was hiding. So Wendy was going to have to face a deposition and face a judge, and it was all going to unravel. And the only way that you could prevent that is if Dan was incapacitated, taken out.
So in part, the volume of what occurred over the divorce proceedings, you want the jury to recognize this goes to motive in some way.
Yes, Your Honor. In reference to hearsay, the items are not being offered for the truth of the matter asserted. There obviously was a litigious divorce, but it's being offered to show the effect on Ms. Adelson. These items were shared with her. The evidence intends to show she was very involved in the pleadings. She was sent the pleadings and offered detailed responses for how Mrs. Wendy Adelson should respond to the pleadings. So it's very bound up in the state's theory of the motive for the case.
I mean, you could say that Donna was even more emotionally invested and financially invested than even Wendy was, because I think they were bankrolling a lot of this, Harvey and Donna, her parents, Wendy's parents. So this is something that was going to be Wendy's downfall, where she could be stuck in Tallahassee without a job. That's why this litigation was becoming so escalated. And it shows that the state of mind also of Dan Markel. Something is defined as hearsay when it's an out-of-court statement offered to prove the truth in the matter asserted. So all the claims made in the litigation, this is not being litigated for that purpose. It's merely offered to show the effect on the listener, how Wendy was responding to what Dan was saying, and how Dan was responding to Wendy's actions. So it's really going to show more or less what the state of mind was of the two parties and how this thing was escalating, and serious accusations being made against Wendy. And Wendy was also making some escalating accusations against Dan, like he hadn't paid the proceeds that she was supposed to be owed out of the house, but then he didn't pay that because he realized that she hid other assets in the disclosure form, and also the fact that he didn't have the Holocaust ring of his family relative that survived the Holocaust torture murder camps in World War II there in Germany. So,
All right. Mr. Zellman, as to your client's emails to her daughter as this litigation was going on, are these contested in any way?
With respect to the initial dissolution proceeding, no. However, in reviewing the emails, the post-dissolution matters that were filed by Mr. Markel, there's no evidence in those emails that those pleadings were shared with Mrs. Adelson. And so certainly, if the state's theory is that it goes to the motive, and that's their way of getting around hearsay, they have to establish that the pleadings were sent to her.
okay, you're telling me that Wendy knew about those, but Donna didn't. She sent them to 12 people, so I think that's a misstatement.
My review of the emails show that did not happen. So they can't go to show my clients.
So Wendy emailed 12 people the last motion you received from Dan, but you never talked to Donna about it, right? That's what you want to have this judge believe.
If she didn't receive that.
All right, as to any pleadings that correspond with emails or communications that were made by the defendant and otherwise demonstrate her role in or some part in the divorce case, as to those, I'm going to rule they are admissible. The pleadings themselves, if they're being offered not for the truth of the matter asserted, but to otherwise demonstrate motive or intent, those are admissible. However, Ms. Keppelman, as to the bulk of the file itself, I do believe the defense is raising a clear point on this. Absent a connection or a nexus between the defendant and specific aspects of the divorce file. What is your argument concerning it?
Yeah, I think if Georgia would have maybe tied the relationship more of how Donna was intricately involved in this case as if she was a party as well to it. She was going to be a witness of this. She was the one encouraging Wendy to fight and do all kinds of wild things like dress up the kids as Hitler Youth and all that kind of stuff. So Wendy is not in this alone. She's actually in many ways has Donna driving the seat on this litigation. So really the entire file should come in.
I mean, there are pleadings in there that are not necessary to show the motive, but I did offer the exhibit itself in its entirety to demonstrate the bulk. If Your Honor is not inclined to allow those pieces of paper that cannot be directly connected to the defendant, may I be permitted to show the exhibit as a demonstrative to the witness to verify that that is the entirety of the divorce file?
It is permitted as a demonstration.
Yeah, this is just a bad audio connection, folks. This was on the other channels. I tried several channels are doing live coverage. So this is coming from the bad court feed. Hopefully they're going to get better court feed for the trial. I talked to John about it. He's going to be talking to them here before the trial starts and see if there's anything that that we can do to get a better feed for the trial and go directly from the court instead of hopping on some other channel like this Law and Crime.
You may also ask questions that generally deal with the amount of filings and also the volume of the case, but ultimately as to responses for production or mediator notices, I'm inclined to agree with the defense as to that point. If there's not either a relevant connection or a nexus between the defendant's actions and then what occurred in the dissolution of marriage case, all of it does not come in as substantive evidence.
Yeah.
But I do want to make clear on this point, Mr. Zellman,
Right.
as to what the witnesses will testify to, and none of us will know this until the evidence actually begins. This file can be used for purposes of impeachment, and it can also be used for purposes of rebuttal. Depending on what the witnesses say, what might be not a part of the state's case in chief may still be available to them through other means.
So what the judge is doing is basically saying, look, you can't object to everything, and we don't even know if it's going to become relevant during the trial. So to blanketly object to entire divorce file, then that's a premature objection. So the judge is sort of saying, like, let's see how this thing unfolds, and you may open the door defense, or the prosecution may have some relevancy here that it should more details of the file should come in. So, and for demonstrative purposes, showing how thick the file is. That's what Georgia is talking about here. So they're going to see that there's a lot of litigation that took place, and there's probably a couple $100,000 between the parties fighting this effort by Wendy to have the boys be moved down to Miami.
Not permitted by the rules of evidence. Is everyone clear on those?
Yes, sir.
Yes, Your Honor.
All right, let's move on to the motion of limine concerning the testimony of Sarah Yousef. Mr. Zellman.
Again, Your Honor, we stand on the motion.
Ms. Cobbin, in response.
I would just ask Your Honor to reserve on her. The state has no intention of calling her, so I don't think, unless that changes, that there's any reason to address her testimony at this time.
Well, and I assume you are going.
I think this I didn't quite hear that. I think are they talking about Sarah Yousef? Are they not going to bring her? I think that's what they were talking about.
To leave Ms. Yousef available as a rebuttal witness if necessary.
Yes.
If a witness is not going to be called, it essentially moots the issue. On that point, Mr. Zellman, the state is not committing to calling this witness. If they do call them at that time, I will issue a ruling concerning your motion in limine.
Yes, sir.
As to any purpose of rebuttal, ultimately what comes out as a part of the defense case, Ms. Yousef still is able to testify in that capacity. All right, the next motion of limine concerning the testimony of Stephen Webster.
Okay,
The defense-
Stephen Webster, that's the attorney for Dan Markell. He's the one that was filing the motion to hold Wendy in contempt, and he said he had a really great case against Wendy. That's why he took the case. He normally does criminal defense, but he agreed to do family law in this case because he was so impressed by Dan, and he felt what a great father he was, and he was being given the runaround by Wendy and just needed to stop. And so he was willing to go to bat for Dan. And so what they're trying to do is keep out Webster's opinion that Dan had a great case and Dan was looking forward to this trial, this hearing that was going to happen in the future month or two down the road.
Have any argument that has not already been made through the pleading?
No, Your Honor.
Ms. Kaplan, response.
Judge, I agree with some of the defendant's motions. I don't think Mr. Webster can offer opinions. For example, his testimony, of course, will be governed by the same rules of evidence that every other witness is governed by, but he does offer some relevant points. So I think I should be permitted to, I don't know, these motions kind of blow my mind because it's like we want to pre-litigate every statement, including potentially objectionable statements that can be addressed during the trial by a proper timely objection. So I would ask that it be handled in that way.
Yeah, so what they're trying to do, like I say, they're trying to have as much blocked pre-trial ahead of time and just do a blanket objection to the guy's testimony completely, just object to Webster's testimony completely. So this is sort of like a weird thing because it is relevant. It should be coming in, and they're just doing everything they can to try to get this before the judge, and hopefully they'll get a winner of some of these before the judge. But the judge should really let all this kind of stuff in, and Georgia should know how to lay proper foundation. One of the exceptions, for example, could be state of mind of Dan Markell and what Webster perceived and what conversations they had. It's not to offer to prove the truth of the matter, but to show the state of mind of Dan, that he really believed he had a good case, and he was looking forward to having better visitation with the boys that was being blocked by Wendy because she was not comporting with the requirements of the custody decree.
All right, concerning the testimony of Mr. Webster, Mr. Webster, in his capacity of representing the deceased, certainly can testify factually as to what his involvement was with the divorce case. And also, he may testify concerning the nature of the proceedings as to any opinions that go beyond that. Ultimately, I think that's where we are going to have to get into what is being asked and what would be the response that ultimately the defense would find objectionable. But generally, as to any opinion that Mr. Webster cannot give without a proper foundation, I think it's settled as a matter of evidence that no witness gets to generally opine on matters in which they are not qualified to testify to. Is any other ruling being sought?
He should be able to testify just like he did last time. Like, look, I was looking really forward to helping this guy out. I thought he had a real strong case, and I was looking forward to representing him. So those kind of things are directly relevant here, and it shows that Dan was in a position to have some big win against Wendy, and Wendy's job at the FSU Law School was only a part-time job. She was a contract type employee. And so with that being the case, Dan being a tenured professor, he could have had Wendy let go at any time if he went to the dean of the law school and said, look, she's done all kinds of stuff here to railroad me, and she's misrepresented things in this divorce proceeding. I can't work around with her in the school. So you know what they would have done? They would have terminated her contract right on the spot. So that's what Wendy would have been doing, is being left without that job and being stuck in Tallahassee. But the murder of Dan Markell radically changed all that.
concerning Mr. Webster beyond that by the defense?
Well, yes, Your Honor. In prior trials and in deposition, Mr. Webster testified about statements made to him by Mr. Markel. Those are hearsay. There's not an exception. Those statements.
Yeah, there is. It's called state of mind. There's 24 exceptions to hearsay. And so that's totally relevant. And he knows it. He's just trying to throw stuff up there. That's
Weren't shared with anyone else, certainly not my client. Those were statements that were made during the meeting in May of 2014 that Mr. Webster. There's no exception that I'm aware of under the hearsay rule.
okay. Well, you know, if you're an attorney, you have a duty to discuss rules and case law that could be against your position as well. So why doesn't he bring up the fact that there's multiple exceptions to hearsay when he brings up these hearsay objections? So I find that troubling that he's not allowing the prosecution to say that there are exceptions, and so doesn't look good. I wouldn't be happy if I was a judge here in
Statements
Texas.
made by the deceased to Mr. Webster. Ms. Kaplan, do you have an argument?
I think I agree in general that those statements would be hearsay. I don't recall what my theory
There's exceptions to hearsay, Donna. There's 24 of them.
of admissibility was in prior trials, but I would agree to
Georgia, I think I called her Donna. So
approach if I intend to elicit a statement made by Mr. Markel to his attorney and offer my theory of admissibility prior to asking the question. If I decide to do that in this trial, I don't think I plan to do that, so it's hard for me to address what that theory might be now.
you better have your theories of how you're going to get evidence in before you start the trial, because they're going to be objecting, and they're going to be objecting probably a lot. And that's why this trial could take longer than what they think it is, because I think these two attorneys here, they know got to lose their case. So they're just going to fling every kind of objection they can against the wall, and it's going to take it longer to be ruled upon. And Georgia and Sarah, they better get their act together here and understand the legal basis that they can ask every question. So in other words, as an attorney, when you go to court, you better be prepared for everything you ask as a question. If it's objected to, how are you going to overcome it? What's your argument to the judge on why it should be admissible? And then have some case law ready to go. If it's really something important that you need to get in there, have the case law ready to go. Don't just be going in there winging it and thinking, well, it is hearsay, so I pretty much agree with it. No, it really goes to show that Dan's state of mind is relevant here, and he believed he had a winner case, and he also spent a lot of money to get this issue remedied with him not having proper visitation with the boys. So I'm just surprised that Georgia's being flat-footed like this.
Well, again, as a general principle of evidence, hearsay that has no exception is not admissible. If the state is seeking to admit this statement for a proper purpose that actually has a basis in the rules of evidence to be admitted, you will need to approach so that way the information is not placed improperly before the jury. The motion.
I still can't believe that Georgia's agreed with him on that. That's really shocking. So, but the judge is basically saying he's sort of saving Georgia by saying he's reserves the ruling on those statements as they come up, and he's saying that you got to have proper foundation, hearsay exceptions applicable, and all that kind of stuff ready to go. So, Georgia, you got time to fix it.
Remedy is granted as to Mr. Webster offering any opinions for which he is not qualified to give. The court will reserve ruling on the issue of any statements that he may testify to by the deceased. If the state, again, will have to present an actual exception to hearsay in which the matter can be placed before the jury. Right, the renewed motion remedy concerning the Latin Kings.
Okay, this Latin Kings motion, this is actually the prosecutor's motion to keep out any reference to Latin kings, which I think is a bad move. Georgia did it in Charlie's trial, did the same motion in limine outside the presence of the jury, and the judge initially granted it, but then ultimately it came in. As I recall, the Latin king reference to Luis Rivera, one of the hitmen. He was a Latin king member, a career Latin king member. And so the judge agreed with the prosecution that that would not come out in the last trial initially, like I said, but then he wound up letting it come in some way because the defense made a big stink about it and said this goes to the heart of their defense. And so defense wants to bring this in, and we'll hear some more about it here before I comment.
Mr. Zelman?
Yes, Your Honor, this goes in part to the theory of the defense and why Mrs. Adelson acted the way she did, the language that she used on the 2016 wire calls.
Oh my gosh. Can you guys believe that? That's how far-fetched this thing is. They're going to say that she knew that this guy was a Latin king member. They didn't even know who Luis Rivera was until after it got announced in the news because Katie never told Charlie. When Charlie was saying, hey, what's going on? And you need to go back and you need to tell Sigfredo that he needs to call out and find out who this other brother thing is. And lo and behold, he would not do that. So what we had was the Latin kings were nowhere discussed and brought up to any of the Adelsons until after much later when this after the wiretap and all that had occurred. So to say that she was fearful and that's why she was talking the way she did in code because he thought it was Latin kings. No, if you thought it was Latin kings, this actually is going to be easy as a prosecutor to counteract because if you thought it was Latin kings that did the bump on you, you would have for sure called the police. You don't deal with murderous gangs, one of the most notorious murderous gangs of Florida. In fact, they're over much of the United States. So it's actually something that's going to blow up in their face if the prosecution does this right.
Typically, I know that we would want to have the foundation laid through her testimony for that, but if the court were to find
foundation laid for her testimony. So right there, he's saying that at which I've been saying, a lot of people have been saying that Donna is going to testify. There's no way she's not going to. So right there, he's saying that basically this is their defense theory, and he knows that to get this out there, they have to go into Donna's state of mind. But she's just going to make a complete fool of herself on the witness stand, and those wiretaps seal her fate. There's no way she's going to be able to explain that away.
our hands in questioning the state's witnesses, it would be too late to wait until she testifies. We would lose the ability to cross the state's witnesses on that issue. It's very.
So he's saying he wants to cross-examine the witnesses for the government on the Latin King aspects and all that. It's like, you know what? As a prosecutor, I'm like, oh, you want to make up something and act like you knew that these are Latin Kings, whatever. Go ahead. I mean, I think there is such a thing as a constitutional right to present a defense. And that's something we never saw in the Karen Reed case. That was shut down massively. It was so unconstitutional, that court, so-called court, as I called it up there in Massachusetts. Here, you know, don't try to hide the ball on something. He was a Latin King member. That's indisputable. So let it be known that he's a Latin King member as far as his career. But you know what? And then this show that the Adelsons had no way of knowing that he was a Latin King member, and then show that that whole defense theory is a lie.
Limited. You have Luis Rivera. There will only be a few questions at most. Potentially Charlie Adelson, depending on when the state calls him. Certainly special agents. I believe it's Jimenez.
Now, in the last trial, he outright testified that he was, I guess, at least pretending or trying to influence.
Yeah, that's a good point. Luis Rivera, who was a Latin King member, he was just going there to support his buddy Sigfredo Garcia. They were lifelong friends. So he was not doing Latin King business. So that's just a big smoke and mirror defense. That
Your client as a member of the Latin Kings gang.
Yes, sir.
All right. To that end, Ms. Kappelman, what is your argument?
Same as my argument has always been on this issue, Judge, which is that Rivera was a gang member. That's why he was recruited to do this. I think that's relevant. But the fact that he was a leader of a specific gang, I think is just bad character evidence that doesn't lend anything additional, more prejudicial than probative, and I would ask to exclude those details.
Similar to what we had in the last trial, as to this painting the character of Mr. Rivera specifically in a negative light, the court's ruling will remain the same. As to the witnesses, though, Mr. Jimenez or other witnesses that may present this topic unsolicited on their directs, once the horse is out of the barn, it's out of the barn. As far as any cross-examination of Mr. Rivera specifically, the defense may cross-examine Mr. Rivera as to his role as a gang member and why he was recruited into this matter to specifically serve a purpose as it relates to the conspiracy of the killing of Dan Markell. Now, with regard to undercover or the former undercover agent, Ms. Kappelman, this is where I believe the analysis begins to diverge on this topic. He specifically approached the defendant as a Latin King member, correct?
No, sir, my recollection is, I mean, I know that was his testimony, but I would instruct him not to say Latin King in the future. However, he didn't say anything to Ms. Adelson about being a Latin King. I guess that was his version of acting like a gang member. I don't know how well he did. Ms. Adelson didn't seem to think he did very well, but that was the intention. He did not represent himself to her verbally as a Latin King gang member. He was not wearing any clothing or other signifiers that he was a member of a specific gang. I think the idea was just, you're an associate of this killer who is a gang member.
Any response on that topic, Mr. Zeldin?
I don't know why George is afraid of bringing up Latin Kings. I mean, I just don't get it. It is what it is.
Just looking at his previous testimony. My role, I'll quote from page 1067 of the trial transcript of Mr. Charlie Adelson's case. Starting at line 20, question, can you explain what that operation was? Answer, my role in that operation, I was portraying a Latin King gang member and I was instructed to conduct the bomb. Continuing on 1068.
Okay, they're talking about the undercover agent. He's supposed to be portraying a Latin King gang member because that's what Rivera was. But Adelson's never knew he was a part of it.
Question is, all right, when you say you were posing as a Latin King gang member, did you announce yourself as a Latin King gang member?
He never identified himself during the bump that he was Latin King. Okay, if he would have said Latin King, for sure they would have called the police. So he just came in there so much under the radar where he's sort of acting like he's part of the gang, but he's not acting intimidating or scary, other than the fact that he's asking for money, and that can be scary to someone like Donna's age back then.
Pushing your approach. I did not. Okay. So you're just, that's the role. That was my role. You're a character. That is correct. That is his testimony. And, you know, I believe that once, especially with the call that my client made to the undercover on May 6th of 2014, when he became verbally aggressive towards my client, that factors into his role as a Latin King gang member. And I know in the previous hearing last year, Your Honor questioned whether there was a difference.
He never said he was Latin Kings, and the Adelsons didn't know Luis Rivera was even in the mix as part of the hit. They thought Sigfredo did it alone, and Katie never told Charlie that, oh, hey, by the way, he brought a buddy with him up there. So you got two people that know about what went on up there as part of the hit team, not just one.
difference between a Latin King gang member and simply a gang member? The answer is absolutely. In Miami, in South Florida, there is absolutely a difference between a gang member and a Latin King gang member.
How's that got anything to do with this case? Nothing. The fact that he was Latin King member. He's a gang member. Okay. He's Latin King. You can even say that, but it really has no direct bearing. And they're trying to make it sound like Donna was so scary because this is like the Latin Kings, not just any gang. It was the Latin Kings, one of the most savage groups of killers down there. So anyway, it's not going to help y'all. So go ahead.
That being
Go ahead, do some
said,
smoke and
this
mirror
ultimately
defense.
goes to your client's state of mind, who is going to establish how she knows the difference between, forgive the pun, the garden variety gang member and a specific gang member.
I think between her testimony and anticipated testimony of Charlie Adelson.
As to the question,
If the Adelsons knew that Latin Kings were part of this hit, they probably would have been scared and been worried about something like a robbery and having them come after them as well. They don't want Latin Kings knowing who they are.
the former undercover officer or special agent Jimenez, I will permit the defense to question the former special agent as to whether he was portraying a member of a specific gang as a part of his bump operation. Depending on what the answer is, we will revisit the issue of whether the name Latin Kings needs to be specifically uttered as to either Mrs. Adelson or Charlie Adelson testifying concerning her state of mind and knowledge of the Latin Kings. As it goes to state of mind, the defense may certainly inquire as to that during the defense case in chief. As to Luis Rivera, the court's ruling will remain the same as to his leadership role or specific affiliation. The fact that he is a gang member may be inquired into, and the fact that he has had, or the fact that he had, or his role while he was recruited in this case, that certainly is ripe for cross-examination and may be inquired into. But as to him being a specific Latin king, that is where the line is going to be drawn. Do we need any clarification on these rulings?
Just a moment, Your Honor.
Not from the state judge.
So the concern we have,
Yeah, the Latin Kings wouldn't respect the fact that they're being accused of doing this hit.
Your Honor, is that Mrs. Adelson, part of her state of mind, her level of fear, is that it's not just that she learned he was Latin King, but that he was the leader of one of the branches of the Latin Kings.
He never told her that. No one told Donna that. Charlie didn't know that. This is all just smoke and mirrors here.
Florida. That heightens her fear. And of course, she will testify to that.
I cannot make
Yeah. Go ahead. If you want to say that Donna's going to get up there and say that, oh yeah, I knew he was part of Latin Kings and that's why I was so scared and all that. Yeah. Go ahead. It makes your defense even that much more ridiculous. Most ridiculous defense you'll ever find in a court of law.
If she is committing to do so as a part of her defense, that's her choice. But ultimately, someone with competent knowledge has to testify to this fact. Eliciting information about the state of mind from the witness that either has not spoken to your client.
Yeah, I mean, she might as well come up and say, I had to leave Florida for a while because the Latin Kings were going to come after me. Not just the knuckle dragger jurors up in Tallahassee that convict me. I had to leave the United States for good. Everybody's coming after me. The law, the gangs.
Either has no knowledge of the state of mind. I'm not sure how that can be accomplished other than either your client herself, her son, or someone else who has direct knowledge of her state of mind at the time, unless you have an argument.
So I guess the way that we could accomplish that, Your Honor, is that Mr. Rivera, he is.
That's true, Carrie. Her phone with Charlie regarding the bump, she did not sound scared at all. She was concerned, but she wasn't. If she was really thinking this was a gang member, she would have right away called the police that day.
Other defense, we would ask that he remain for the defense case so that we can call him on our case in chief.
That's fine. Mr. Rivera, as I recall, never had any direct communication with your client, but this is to elicit another relevant matter.
That's correct, Your Honor. It would be, once we establish the foundation, I would want to recall him for the specific purpose of him confirming that he was a leader of the Latin Kings.
Very well.
Good. Good. Make your defense all that much more ridiculous. Go for it, Zellman. I'm saying bring it on. Do that.
Mr. Rivera will remain under the defense's subpoena until the conclusion of the trial. Let's move on to the defendant's motion of limine as to the interpretation of emails, recorded phone calls, and text messages. Which witnesses is the defense referring to concerning this motion?
I think it goes really to retired Detective Isom, Special Agent Sanford, potentially Jason Newland. I think a number of witnesses have offered interpretation of statements that were made. Now, we're not talking about coded language. Coded language is treated different. What we're talking about is the emails, the recorded phone calls, and text messages, other than coded language. What we're asking the court, because it has come out so frequently.
So he's trying to say that investigators or law enforcement types, their interpretation on what the conversation was discussing, that should not be admissible. So it's
That the court prohibit the state, and what's good for the goose is good for the gander, the defense, from asking someone other than an expert to offer an opinion about what someone means by an email, what they meant by a statement, or what they meant in a text message.
they can say what law enforcement interpreted that to mean. And so some of it's a lot of this anyway is just common sense. I'd say most all of it is common sense.
Aside from the language that's used itself.
Ms. Coleman, response?
I agree, that would not be admissible.
Motion in limine is granted as previously raised in the argument on this matter. Any matters that would go to a code in which a witness could lay a proper foundation on this issue. So,
As I've said before, the Latin Kings were not wiretapping your phone, Donna, when you're talking to Charlie. So why were you talking in such a hushed manner and trying to talk in code to Charlie? Because you knew it was an eavesdrop that you're worried about, not the Latin Kings. You're worried about law enforcement tapping your lines.
certainly they may testify as to that point, but any general opining as to what an email, a phone call, or a text message means will not be permitted unless there is a proper foundation that can be laid by that witness. Next, the defendant's renewed motion in limine concerning travel as consciousness of guilt.
Jubilee, you're asking at this stage where the chances Donna is offered or accepts an offered plea. Offered plea is a plea of no contest. It basically, you don't have to admit to guilt. You can just stipulate that the evidence, if it were to admitted at trial, that you'd be found guilty. So it's a way to not have to accept responsibility, but yet you accept the fact that legally there's enough evidence to find you guilty. So that's what an offered plea is. And so in this particular case here, I don't think there's any chance. When you see Donna laughing like that in court before this started, before the judge came out on the bench, that's a good sign that she thinks she's got this thing in the bag. She's going home. She's as delusional as Charlie.
Your Honor, I know that the court previously ruled on this issue that allowed the state to use this information in their argument. The new information as I've laid out in paragraphs 4, 5, 6, and 7.
Tiffany Nicole, why is the state acting like Charlie will testify? There's no way his appellate attorneys will allow that, right? Well, there's still a statute that can force somebody to be testifying for the state. So that's what the state is going to rely upon. So even though he's got an appellate matter pending, he can be forced to testify. And if he doesn't, he could be held in contempt. But when you're facing a life without parole sentence, how's that really going to punish him, right? But if Charlie's thinking he's going to walk, he's going to want to testify and help mom, right? So the thing is, if the defense calls him, he doesn't have that immunity protection. If the prosecution calls him, then whatever he says, that cannot be used against him in his own case that he has on appeal right now.
I stand on the motion. Those additional pieces of information had not previously been provided before, and I think that it's significant because it goes to her state of mind for making the travel plans and for going to the airport and for stepping on the jet.
That's a really sore spot for them. They're trying to keep out the flight consciousness of guilt instruction. He's saying that there was no knowledge that Donna had a warrant out for her arrest. But you know what? She's trying to flee the jurisdiction, so they could not effectuate an upcoming warrant. So it is consciousness of guilt, and that the judge did.
Recalling prior counsel's argument correctly, if Mr. Rashbaum did raise the fact that there was no legal process, subpoena or warrant for your client, correct?
I believe that's correct.
Man, you got Rashbaum on tape advising Donna it's about to happen. It could happen, and he may not be able to get out of the country. So yeah, that's consciousness of guilt.
Response, Ms. Kaplan?
Judge, I don't think this is new information. This was never disputed. I don't think it changes the analysis.
On this particular point, the court has reviewed the transcripts of the depositions that were cited by the renewed motion, and the ruling will remain the same on this issue as before. These matters go to the weight of the evidence and not the admissibility. The jury, as the trier of fact, is going to decide what significance to give to the evidence. The defense also is free to cross-examine on all issues that pertain to Mrs. Adelson being free to travel. The matters that have been previously raised within the motion to suppress and rule on as to the phone calls and other evidence, that also will be presented to the jury as well. They will make up their mind.
Thank you, sir.
Yep. He's just renewing it because he knows that it's relevant, it's very damning, and they're not going to win this case, but he's trying to win it here in the rulings because he's not going to win it with a jury. Tanya, Bluebell, the bump worked flawlessly. It got everyone involved except Wendy to talk. Why didn't they wiretap Wendy? Well, because Wendy did such a good job of pointing the finger at other people, including her family. So that's why I think they did not include Wendy in that. They learned sometime after that how much they got it wrong and how Jeff Lacasse had basically set this whole thing up like bowling pins for them, that they just couldn't see it for what it was.
Well, I believe that covers the defense motions. And Ms. Kaplan, you stated that the state did not have an additional motion to run those that not have been previously ruled on.
That's correct, Your Honor.
Judge, there's one additional one also filed on July 21st concerning the opinion testimony of Jason Nolan and Patrick Sanford.
Oh, yes. Go ahead as to that motion.
Sorry, Your Honor. I'll stand on the motion.
Ms. Kaplan, response?
Judge, the defense elicited personal opinions of these witnesses at deposition about the lawyers and their ethics and how they think they might have been involved in the new investigation, and now seeks to suppress those opinions, which are clearly inadmissible. I don't understand it. I don't know why we're doing it. I would never elicit such a thing.
Well, Ms. Kaplan, even though it might be inquired into in deposition, ultimately, if there's a basis to exclude it pre-trial, that's why it's being raised now.
Of course, there is no reason to elicit it at deposition, and it could never be admissible in a trial. So we're just wasting paper and time, these motions. No objection.
The state is conceding the issue. The motion is granted as to any opinions that would be offered by an investigator Newland or Special Agent Sanford. Again, there must be a proper foundation for them to offer an opinion on a subject. If they don't have the ability to do so, it cannot be presented as a part of the case in chief.
So basically, the two agents, one Sanford from the FBI, a special agent with them, and then Newland, he's a state attorney office investigator. And so the judge is basically saying the motion is granted where their opinions cannot be presented. So they can talk about what they were doing as a part of their investigation into things about Donna, but they cannot talk about personal opinions and beliefs apparently from this ruling. So they'll be able to get the main guts of what they did and why they did it in. So I'm not so concerned about this one.
I don't really see a context in which this might come around either in rebuttal or as far as impeachment, but again, these rulings are being made as to the state's, the substantive evidence the state may present as a part of its case in chief. If it needs to be readdressed as a matter of either impeachment or rebuttal, I'll take it up at the appropriate time. All right, let's go ahead and talk through some of the logistics for jury selection on 8/19. We are going to be in this courtroom once again. I believe the number of jurors that we have under summons right now, the respective jurors under summons, I believe it's near 300. So what we're going to do on that Tuesday, essentially we will have the pre-screen of jurors on the issue of pretrial publicity, similar to what we did in the last trial. The court will be asking these same questions, or substantially the same questions. Both parties will have an opportunity to follow up on the court's questions on the issue of pretrial publicity. If a prospective juror is deemed suitable to return for a group voir dire, from there they will be given the date and time for which group voir dire will begin. For the pre-screening that will take place on both Tuesday morning, Tuesday afternoon, potentially Wednesday morning and Wednesday afternoon, I would anticipate by that point we would have a suitable pool of jurors from which, going through the pre-screen process, anyone who has had an issue or either the court believes, the state believes, or the defense believes is not suitable to go to the group.
Sean's asking how much this case cost Donna. I think she's probably paid $750,000 for each one of these attorneys. So she's probably paying 1.5 million. 1.3 to 1.5 million between two of these. Plus, they got a number of experts as well. That's probably going to be 100,000 on top of that.
From there,
Just a guess.
each party will have an opportunity to make their objections known as to that respective juror, and they'll be told to return, or they will be excused at that point. Does anyone have a question about the pre-screening process?
No, sir.
There you are. Also, as well, so that we don't have any issues similar to what occurred in the previous trial, in which I believe there were allegations the jurors were speaking to each other. We are going to have additional bailiffs. The prospective jurors are going to be instructed not to speak to each other. It might make a long day for them, but they will be sitting in silence. We will provide reading material to them. And we'll have extra bailiffs on hand to ensure that no one is speaking to each other while they're waiting to be screened. Does anyone have anything they need to raise concerning those?
Is it your honor's intention to handle the pre-screening, I don't know what it's called, instructions that happen down in jury assembly?
Yes.
Okay.
I believe last time, I'm not sure if someone else qualified or not, but for each group that will be qualified, I will do it personally, so that way from beginning to end, they're seeing me, hearing me, and understanding you're not to discuss the case or anything else with each other.
Perfect, that's the state's request.
Judge, how many of the 300 are coming each day?
I got
Broken up
300.
into groups of 50, so 50 in the morning, 50 in the afternoon.
So the judge saying 50 in the morning, 50 in the afternoon are going to be the part of the jury pool that they're going to have a chance to voir dire, and most of those are going to be one-on-ones. They're not going to have as much of the time for group jury selection.
We may not even need to get to the end of this grouping altogether if we are able to go through the pre-screening process on the issue of pretrial publicity. Once we have, say, 100 to 110, that's more than enough to get 12 people.
Last time they got through 150, and they were able to pick a jury out of the first 150, so they got double that this time. I think they'll be able to pick them within the first 150 as well.
How do you
They need 12 jurors, and then they'll have 3 alternates.
intend to handle proceeding once we successfully select a jury?
Once we have selected a jury at that point, and also I believe too, we'll need at least 2 alternates unless the parties wish to have 3.
The best request for Your Honor.
So, then once we have our 12 jurors and 3 alternates, at that point, we will swear them. If we have enough time to actually move into opening on that same day at the selection, we'll do that, so that way we can start to begin into witness testimony seamlessly without issue. How many days is the state anticipating to go through its case in chief?
I think best case scenario is 5, worst 7. So
I don't know how they're going to get through in 5 to 7 days. I think it's going to take longer. Like I say, I think they're going to have a lot more objections during the trial by the defense team than what they had with Rashbaum.
6. I could see how it could run into the first part of the 7th day, Judge. I think 6 is a comfortable estimate.
She's thinking best guesstimate is 6 days, could spill over to 7. I don't see how that's possible, but
Calendar. Assuming that we have a jury by Friday the 22nd, and know that in place August 25th through September 2nd as the state's case in chief. I think there is a holiday on September 1st, correct?
Yes, sir.
Is anyone long-term work on Labor Day?
Jackie is.
I need one other hand, unrelated to that side of the table.
all right. There's one time the judge is laughing, but he's not laughing much about, like, say anything with these Adelsons, because it's just been nothing but a hot mess and nothing but a thorn in his side.
There's a holiday for the workers of the world, but we cannot forget that we have a trial to finish. All right, 8:25 through 9:02, then we're estimating as the state's case in chief. How long is the defense estimating to present?
Yes, Wendy will be testifying. She's forced to testify as a state witness.
Case that it wishes to do so.
Can I weigh in on that before they speak, Judge? We have historically picked a jury in 3 days at the longest. Twice we did it in 2 days. So my suggestion would be to start on Friday. We could even do openings as early as Thursday, if Your Honor was willing to entertain that. I know that's not the defense's request, but that would be the state's request, just to move it on as quickly as possible.
Well, for the openings only, does the defense have a position concerning this?
Good. We don't want to make the openings unless we have a great deal of time after we pick the jury on a particular day. We would prefer to do the openings the next day.
So you're not asking to defer your opening to your case, you just don't want to open on the same day?
It's going to depend, Judge, on your ruling on the additional motion.
Right?
Okay, so they're waiting to see what the judge's ruling is on some other motion, the one probably we don't know about that's sealed, and that the judge is asking about, are they going to defer their opening? In other words, the defense opening could be after the government rests their case in chief. And so that's normally not the way attorneys do it. Sometimes you see that once in a while. I don't think I've ever done that. I always like doing the opening in the beginning so that the jury knows what I plan on delivering, and I want to right away counter what the prosecution is saying that's incorrect, rather than let it linger. And of course, when I'm a prosecutor, you always have the case in chief first before the defense. So you'll always have an opening in the beginning because your case in chief is before the defense goes. So
That matter, again,
So they're just basically what this attorney Jackie Fulford is arguing is like, we just don't want to go right after the jury selected and right away jump into openings without having a day to regroup. So
depending on where we're at time-wise, I'll just instruct both parties to be.
but the thing is, if you have a half day left, why wouldn't you just want to go right into arguments? I don't understand why a defense attorney would say that. Are you that burned out from jury selection that you can't argue right away?
Prepared to potentially give their openings. I'm not going to place a time limit on the opening statements, but obviously, well, each party will be the captain of its own ship as to how you'll captivate the jurors. Is either party expecting their opening to go beyond 30 minutes?
Depends on your ruling, Judge.
Ms. Calhoun?
Yes, I think it could be up to 45 minutes. It's not going to be different than it was previously, but I'm sorry, I don't know how long it was. I would say 30 to 45.
See, she's got about the same opening argument as what she had for Charlie's case. She just admitted that, and that proves my point. You should have tried multiple Adelsons together. But anyway, that's me. You just have to do all this extra work.
I was comfortable range, Judge.
Right, as to the defense case, once we are finished with the state's case, how much time are you estimating?
It depends on your ruling, Judge, but anywhere between 4 and 6 days.
4 and 6 days.
4 to 6 days of witnesses. Yeah. Well, remember Rajbaum said his was going to be 3 weeks, and he had what? Just a couple witnesses, and Charlie is all. So I don't see 4 to 6 days. I'd say maybe
That
3 at
would place
most.
us then around
3 to 4 at most.
the week of September 8th. Concerning any other matters that we can address as the logistics of the trial, I believe we will have rooms available for our family members.
The defense attorneys are just two separate attorneys. Donna had money to spend on not just one, but 2 attorneys. So no, they're not a couple.
Both for the victim's family and for the defendant, do the parties anticipate making use of these rooms?
Yes, Your Honor.
Yes, sir.
Right.
All right. So yeah, Donna's not only in handcuffs, she's also in leg irons. So she's got both her wrists in handcuffs, and then she also has leg cuffs around her ankles, and they also have a chain that goes between the 2 cuffs, and that also goes around her waist. So she's really chained up, so she cannot run. There's no way she could run at all. So to get in and out of the court, she just has to do a shuffle, because if you walk too fast, you fall flat on your face because your legs will get caught up and trip you with the
Contact
short chain
administration.
connecting the 2
From
around your
there,
chest.
You'll receive information as to how to access the rooms and when they will be made available.
Judge, can I clarify your intentions about when to start testimony?
Go ahead.
intend to start testimony on the 25th, is that right? With the possibility of openings having already been conducted?
Well, at the latest, if we go into Friday with needing to select a jury,
If we get a jury,
if we get a jury prior to that Friday, on say the 21st, really at that point, there's nothing preventing the testimony from getting started on the 22nd.
okay, so I'll be prepared to start testimony on the 22nd then, and my understanding was, and my subpoenas run through September 5th, but it sounds like we might be extending into the week of September 8th, is that right?
Well, I believe the defense is indicating they might need anywhere from 4 to 6 days.
That's what they said. All right, so we could potentially go through the week of the 8th.
If need be.
All right, I will,
So I think she said it potentially could go through the week of the 8th. 8th of September, Sunday the 7th is when that week starts. So Monday the 8th. So yeah, I think there's a good chance it could go into the week of starting on the 8th of September.
attempt to get subpoenas out for rebuttal for that week, but I will advise the court that as of right now, those are not out.
We are losing a day because of September 1. But if need be, we can figure out logistically how to make this work for Saturday, to continue working. I'm sure you all would like a break, but I'm here. As far as having matters of logistics that need to raise considering travel.
Yeah, Judge, we're gonna have an issue regarding space. We're not all gonna fit here. We also don't want our computer screens facing cameras.
I mean, her and Donna look like sisters, don't they? I mean, they look so much alike. And I think they act a lot alike too. I don't know. I think it's uncanny how this is happening, and I'm thinking she's not going to do so good for Donna.
And the audience being able to see what's on our computer screens. I have become very old, and the font size I use is very large, and probably someone in the back row can see what I have on my computer, so we're gonna need to have, I understand we're blocked by this column,
Right.
but we're gonna need to have some kind of setup where we can put our things and our defense not be disclosed ahead of time to the media and blogs and this and that. The second
Blog. She doesn't want any of the bloggers coming in there and being able to read her screen. I mean, do something outside the presence of the judge. You get this rectified with the court administrator there, or the judge's administrator for him. But they want to bring it up in hearing for the judge. I guess go ahead, and you're going to have to move your table or add more tables. This just seems like it's really something that can be easily fixed rather than saying you can't have people behind you for the first couple rows.
thing is, these microphones used to have the ability that you could touch it and it would turn off. My client is hard of hearing, so she talks loud.
Yeah, and she's not good with hot mics either.
So everything she says is going to be picked up.
Yeah,
This one is now set up so you have to press.
just like it was with Charlie on the jailhouse calls, where she thought the line was dropped on Charlie's end.
Press it each time you want to mute it. And like press and hold, you got to hold it down for it to continue to stay muted.
That might, you may think that's going to help you, Jackie, but you know what? With Donna there, she's not going to operate that button the right way, and so there's going to be another hot mic moment for the jury to hear, perhaps. Better have Donna just do pen and paper messages instead of talking.
And we're going to ask if the court admin could put it back to the function where we can push it off. I don't think there's going to be any opportunity in the trial for someone to not pick up on a recording of Mr. Zellman's voice. He's very loud. I tend to be loud too.
Zellman's loud? I've never heard him be loud yet. He seems like really quiet. You can hardly hear the guy.
So it's not going to be a record issue in our position, but it's certainly going to be a problem when we're trying to speak to our client.
No contact whatsoever. From what we've gathered, there's zero contact with Wendy and Donna. So this is going on 21 months, no contact between Wendy and Donna.
About something because it's going to be heard.
Well, in front of the jury, I definitely understand the concern that we're registering with this. One client, what can be done for the microphone on the table. If your client does need to write things down, so that way nothing's being given away, that might be the easiest way for that to be handled, but that requires the microphone. The seating set up in the gallery, I believe the first two rows behind the fence, those are not going to be available to any members of media.
Yes, I believe Donna's on some kind of antidepressants, probably some anti-anxiety pills. So that's stuff that can change your personality. So I don't know how she's thinking that's going to help her. It may calm her down temporarily, but there can be other side effects.
As far as the font size of your computer, if you need to rearrange how you're seated at the table, so if you need a seat on the far left, or my right, your left, so that way your computer can face the wall and no one can see it.
Yeah, she owns a funeral home. That's what the word is.
I don't really know what I can accommodate you with as far as that font size beyond that.
Well, the problem is the end of the table it's not open. It's the leg of the table. So I don't know if we can add a little something, another table that is the same size.
When I've tried a 3 co-defendant first degree murder trial in this room before, and what we had done was one table was between the column and the bailiff's box. There was a table here and then this table here. I think that if we could put a table to our left, that might be one way of accommodating this.
Right. Please make a request to the court admin, we will figure out the best way to try to configure the tables. Ultimately, for what needs to come in with, I believe the state is going to try to, or needs to bring in its equipment, audio equipment.
Yes, Your Honor.
All right. Because of that equipment, how it will need to be set up, the tables, and how they're configured can't interfere with that. We'll try to accommodate that as best as possible. Comment as to the audio visual needs of the state, other than what has been used before with the audio setup. Is there anything that needs to be addressed?
No, sir, it'll be the same setup with the same company.
All right.
I can't believe the judge's court assistants haven't given him better audio connection here. That's unacceptable.
Probably then they'll need to get started.
Yes, Mary James, you're asking, are they still raising the issue of a change of venue? Is that why they'll pick from a potential jury of 300? Yes, that's exactly why. They want to make sure if this case is so permeated to the public and the jury pool, they all have conclusions about Donna's guilt, that, then the judge would have to grant a motion for change of venue. But that's not going to happen because there's not enough people that know about the case. This case is over 11 years old, and there's a lot of people that are transients there. There are a lot of college students, so they won't have any problems finding a juror of 12 plus 3 alternates.
Started by the 15th in this room, so they can set up all equipment, test the equipment, and if there's any problems, we'll be able to figure out what needs to take place before we actually get started on the 19th. All right. For the immediate presence that will be here as well, I believe it would be similar rules as it's been in the past. There will be one live video camera, there will be one still frame camera. Obviously, the bloggers and reporters, they are permitted to take notes as if they were print journalists. But the initial rows behind the state, Ms. Kappelman, I assume the victim's family is wishing to appear.
Yes, Your Honor.
All right, they will receive priority seating with regard to how they're positioned in the gallery. After that, it will be free to the public and the press to seat in all areas that are available. Does other party need to be heard concerning those?
Your Honor, we're also going to need space for our client's family and friends who are going to be coming.
Client's family, who's showing up? Wendy's not going to be able to sit back there, and even if she's released as a witness, she's not going to sit back there. She's going to run to the airport. Charlie, he's going to be locked up somewhere waiting to testify. He's not going to be sitting on the bench there in handcuffs and leg irons in his prison garb. So what family are you talking about?
To support her as well. And we would request that they have similar priority seating as the victim's family.
Well, if you're asking for them to have primary seating, does that negate Jackie's request to have the first two benches cleared out so people can't look at her screen?
That's what the two rows will be behind the defense that will be available to family and friends. Again, similar to last trial, other than the video recording and still frame photography recording, beyond that, no cell phones are to be out recording any other matters or trying to take photos of the witnesses or the jurors. I believe similar in the last trial when Special Agent Jimenez testified, his face was not shown, obviously because of the nature of his past work.
Okay, so you, Special Agent Jimenez apparently is retired. So the judge saying last time his face was not shown. You can see him on the bump. You can see him from a distance with that grainy film, what he looks like. But in court, his face will not be shown.
The court will just make the same ruling concerning that as well.
I'm talking about for the camera. Obviously, the jury will see his face.
His face is not to be shown, but of course, the substance of his testimony certainly may be reported on by anyone who believes it is newsworthy. During the selection of the jury, the faces of the prospective jurors are not to be shown. Their names are not to be shared. But as far as any biographical type data, such as the composition of the jury, being, for example, 7 male, 5 female, what their professions are, those are certainly able to be reported on by the members of the media and disseminated. But ultimately, what I'm getting at is names and faces, so we don't have any disruption or disturbance during the trial. Do any of the parties have any questions concerning those?
No, Your Honor.
There you are. One last thing, typically, I don't think I've had a trial with you quite some time. Typically, my paralegal sits with us, so that's another reason why we need that additional table. She also may have some additional people assisting her, and I'll make sure that they're identified as the bailiffs so that there are no issues there.
Gosh, I hope we have better audio. I mean, this guy talks so low key, it's hard to understand him. And so,
Members of the direct support staffs may sit on the benches that are behind the attorneys, or if we need to figure out a table configuration for them, if we have the space. But the direct support staff is permitted as to both sides. Does either party have anything further to raise concerning the logistics of the trial or any other issues before we finish?
No, Your Honor.
There you are.
One other matter comes to mind if the attorneys can briefly approach.
all right, so now they go up there for a sidebar. They're talking about probably some motion in limine that we don't have the details of. Maybe having to do with the informants. There's a lot of stuff blacked out of a motion. And it could have to do with this. Was there any offer to plea? Are we really going to trial here? We heard this information that was falsely reported that there was a plea offer that was rejected. So those are the kind of things they're probably discussing right now. Notice how being in leg irons and hand irons, she's not going to walk up there and listen in. They're just leaving her at the table there. There's a couple of bailiffs and jailers there in the courtroom. If she did try to bolt, they'd be able to get to her right away. There you can see the handcuffs. Camera guy focuses on that. So they're not going to be able, the jury won't be able to see Donna in handcuffs. So they'll have some extra security guys in there and they won't have her hands in any handcuffs. They may have some leg shackles there. They may shackle her to the table or something like that. Or they may have her completely free, not sure. But if she doesn't have any leg irons or handcuffs on, they'll be making sure they have extra security there outside the courtroom. They're not going to have it look like they got 20 cops there to tackle her if she tries to flee. So they don't want to look like there's an alarming amount of law enforcement in the room when she's there that have a prejudicial effect. Hey, Mona, you're saying Donna's on Zyprexa antipsychotic med. You saw that on a FOIA doc. She's not receiving that med one night. Boy, she's on antipsychotic meds. That's really potent stuff. That can really mess with you. So JBZ, do they do a shock belt in Tennessee? Yeah, I'm not in Tennessee. I'm in Texas, but if it needs to be done, you can see that happen. I've never seen it happen in any kind of court case that I was a part of. It's really rare. But it's probably becoming more common nowadays because you have so many people that are just going mad. Zyprexa can make you gain 40 pounds in a month too. I'm not surprised. Beachbum, you're saying Daybell had a shock vest on. Yeah, I didn't see that case. Familiar with it, but I did not watch it.
We will be in recess for today. The jury selection will start August 19th at 8:30 in the morning after the initial group of jurors has been qualified. From there, we will move into the pre-screening process as previously discussed. Have a good day, everyone.
Thank you, Judge.
Dr. Latina, you're describing Zyprexa as a second generation antipsychotic, which is considered a mood stabilizer, which we use the vast majority of times not for psychosis, rather it is used for mood liability. So maybe that's why Donna could be laughing at the beginning of this proceeding. If somebody's on an antipsychotic and their whole life is on the line, they got to testify. Man, that's a scary proposition. Yeah, so that will affect her. She won't have her normal thinking hat on. And that's the end of it here. So yeah, not too eventful. I think the biggest takeaway for me is I'm just surprised still that they weren't prepared better to discuss hearsay exceptions. Talking about Georgia here. Yeah, in light, you're asking, has anyone ever learned if Wendy was in Colorado for real? Mr. Markel had been in a chat on a prior live by Carl and mentioned that, but did not know for sure. Yeah, so Phil Markel, he did not even know where his grandchildren are. That's the kind of mother that Wendy has been to these boys, or they don't even know. They can't even tell their grandparents where they're at, where they moved to. They can't visit their have their grandparents visit them. They've never been to Canada since Dan has died to visit Dan's grave, their dad's grave. So it's just so outrageously despicable. So if you guys got any questions, go ahead, shoot them with a rage emoji. I'll try to get to a number here still. Taylor J is claiming hearsay regarding statements of Dan Markel, sort of like benefiting from the crime. He would be available if not for the murder, right? Yes, that's true. But unless there's like a dying declaration, then hearsay statements usually have to come in through only an exception, or if it's offered for non-hearsay purposes. But I'm confident if Georgia would just explain that, look, this is to show Dan's state of mind, and he was feeling very enthusiastic about being able to prove that he was wronged in the court proceeding. Because think about it, if they can't bring that out in the last trial, Rashbaum had called the lawyer for Wendy, who said like, "Oh, it's not a big deal. All this litigation, there's no motive there to get any of the Adelsons riled up because it wasn't a big deal. It was Wendy was not going to win, and it wasn't something that she would be really frantic over or angry about. So they tried to downplay it. The defense did, but this thing was heating up, just like Dan said it was. So those should come in under state of mind of Dan Markel. Tiny Bluebell. Do I think Georgia's doing a copy paste from Charlie's trial and perhaps less prepared? I sure hope that's not the case. You know, saying she's only going to do it 5 to 7 days, or if they're trying to do a streamlined version of this, that's not a good thing to see. I consistently have won cases by knowing the details better than my opposing counsel. That is critical. You got to know the law better than your opposing counsel, and you got to know the facts better. Those are two baseline things to be a successful trial attorney, whether it's civil or criminal. Some old times. Did you follow the Brooks Houck case? If they could convict him, can they get Wendy? But they can get Wendy. Yeah, I agree. Brooks Houck. I started to follow that in the beginning. And I know my brother John went there to the courthouse, made some contacts, and I was on their email distribution list of court filings. But that one I had only heard about it because I didn't have time to follow it once it went to trial, and it didn't last very long. It wasn't televised. If it was televised, I probably would have covered it. But yeah, they didn't find the body, and they had just circumstantial evidence to convict him, from what I understand. So a lot less than what we have on Wendy. So I agree with your point there. And then you're saying you saw on another channel that Wendy has a P.O. box, Colorado, but she lives in Austin with her boyfriend, George. Yeah, I don't really care what her living arrangement is. I just want to know, why don't the Markells know where the boys are at? That's just cruel, extremely cruel to the Markell family. John Smith, would the drugs be a reason for an appeal? No, you're talking about the drugs that they were on, Xanax, during the time all their conversations are going on and planning the murder. They could try to use that for a defense, but it wouldn't work. I've never seen anybody try to use any kind of antidepressant defense. I guess you've seen Prozac defense and stuff like that, but that's when they have to admit, yeah, I did it. But the reason I did it was because I wasn't in my right state of mind. It's like a state of temporary state of insanity. So they're not going to ever admit it and then claim some kind of insanity or medical justification that they're on some kind of psych meds that overrid their ability to prevent themselves from turning violent. Catastrophe, you're saying Webster did the right thing and gave Wendy's lawyer a heads up before filing, and so Dan was dead. I cannot remember if I remember hearing about that through his testimony at trial, though. Dr. Latina, you're saying is incredibly damaging to the spirits of young children. It speaks to the ruthlessness of the hard-hearted Adelson family. Yes, it is. And so that's one of my biggest concerns about this is a streamlined light version of Charlie trial. Why aren't they bringing in one of the either Phil or Ruth to testify to the lack of visitation? I mean, that's what this whole case is about. The divorce is like, we don't want Markells around the boys. The boys are ours. The sunshines, as Donna had called them, her sunshines. They were supposed to only be around the Southern Florida Adelsons, and they wanted to punch out anything having to do with Markel. So having a Markel testify would be like a really good thing. And because you know what? The hatred against the Markells, the sweet Markel family, is just so bizarre. It's so extreme and outrageous. So why wouldn't you want to play that out in the courtroom if you're the prosecutor? Have Phil and Ruth get up there and talk about what has been done about denying them visitation, that they don't even really know their grandkids. Have the jury see that. And you know what? Because people are saying, well, Donna, we're worried about a jury being sympathetic to her age. You know what? When you see what the Phil and Ruth have gone through, that's like a way more than an equalizer. That's a slam dunk crushing thing that would be putting a jury on fire to say, how dare these Adelsons treat the Markells this way? It's an ongoing crime to this day, the way the Markells have been treated. So the jury's not going to hear that from any of the Markells because they're not listed on the witness list. Unless they're going to call them in rebuttal. And if Wendy says, oh, yeah, they have unfettered access to the boys like she testified in trial last time, complete lie. Markells have not had unfettered access to the boys at any time in their lifetime. And now what are they, 15 and 16 years old? Irene, what if Harvey's arrested next? Would he give up Wendy to save himself and to possibly reduce Donna's sentence? Boy, so if all of them got arrested except for Wendy, would they decide to circle the wagons? Possibly, but who knows? These guys are all cooked up on meds probably still, so they're not having any kind of rational thinking. Sarasota, if Katie would have flipped, do you think Wendy could have been tried already? Yeah, I think all these folks would have been like dominoes. But that's what that's what happens when you have atrocious lawyering for Katie. If you had good lawyers, they're not afraid to take on a client, call them out on their whacked out thinking, and get tough with them. A really easy thing to do with a client, if they are giving you some nonsense, oh, I'm innocent and I want to go fight this thing, and I'm looking at the death penalty. Katie in the first trial was looking at the death penalty, and they took it off in the second trial. And you know what? The lawyers let her go through that, and they never confronted her and say, you know, you're going down. There's no way you're going to get acquitted. You're going to be found guilty. So why don't we cut you a deal? So you're going to give up capital murder instead of getting out of this capital murder. You could get home free by just telling the truth, but instead you're going to stay on your stupid lies. So you know what? If you want a lawyer representing you that you think you can outsmart, and that's how you want to go, you want to roll the dice and face capital murder. If you want to do some stupid, reckless decision like that, I'm not going to be on this case anymore. I'll withdraw. So you can get some lawyer that will believe anything you tell them, and you know what? You can go to trial and get convicted and be given capital murder death sentence, or you can get life without parole. That's going to be the ultimate outcome. So if you don't have a lawyer that's going to confront a client making such a reckless decision like that, I don't get it. Kristen H. Wendy deleted a text message of the morning of the murder to Charlie that said, "That's so sweet." Why delete that? That was the only thing she deleted also that day. Trevor Ross, you need to follow this channel more. You'll see. We just did another indicator list of some of the indicators. There's other ones out there, a number of other ones, but we had up to 109. Eileen Girl, Wendy has been very calculated from day one. Her only mistake was to write. No, there's a lot more states than that. Go look at my indicator list. She has oodles of mistakes. Bluebird, is the Latin King craziness because they are locked into the extortion theory? Yeah, they're not going to be able to come up with a different defense other than Charlie's, and Charlie's was the most ridiculous ever. And whatever daylight Donna tries to create between her and Charlie, it's just not going to work. It's more of a sympathy ploy. I was scared, so I was just doing what my son told me, and so that's what they're signaling already. So it's not going to work. Spire JFK, you're saying I should help the prosecutors with a few things with my knowledge and passion. Well, they don't want my help. I can assure you that. They believe they got the handle on this. But I'd be more than happy to help them out if they gave me a call. Or if they wanted me to come down there and try a case, I could do that as well. Claudia, is Georgia going to use the same opening as Charlie's trial? Well, it sounds like she's pretty much just dusting it off the shelf. So, yeah, that's what it sounds like. There's a few nuances. like the flight attempt to Vietnam to flee arrest. And whatever she did, I'm telling you, whatever she did in jail, trying to find some other people to do bad things to Katie and their own son, Dr. Rob Adelson, as well as who's the other one? Oh, the mom of Katie, I think it was a relative of Katie. So whatever they were trying to do to obstruct justice and intimidate witnesses. Yeah, that stuff, if that comes out, man, that's just going to be a slam dunk win, even more so. Yeah, I just don't want to get into what Wendy's doing now, who she's got photos with. So thanks for asking. Let her live her life however she wants to, but the bottom line is the Markel should know where the boys are living. Hello, back to Germany there. It's early in the morning for y'all there. Yeah, I was thinking about doing a live stream where I basically role played how I would talk to each of the co-conspirators to get them to do the right thing. Because the only one that really did the right thing to help save themselves was Luis Rivera, a career Latin King member. You think he'd be the last guy to cooperate and turn state's evidence? JVZ, do I think the boys have been so brainwashed that the boys have no idea? Yeah, I think they really have no clue what's really going on one hand. But the other hand, I think kids have the ability to know and read their parents, I think, when something's really strange or bizarre and they're acting weird. I think there is a ability for kids to pick up on that. Dr. Latino, you're saying that in the current family court settings, parental alienation by family members of the opposing side is considered one of the worst behaviors. Judges do not look kindly on alienating children. I don't think judges even comprehend, and they don't really deal with this and address it. That's why it's so pervasive and so many parents get away with it. I think it's really one of the horrible things that goes on in family courts. Family courts are not a really good place for correcting wrongs and abuses of any kind, where there's financial abuse, hiding assets, just like when he was getting away with it. And so anyway, I'm just not impressed with family courts. Yeah, then I already asked your question, but yeah, if you can't do the red, it's an emoji. I guess the red question mark's an emoji. But I saw you here with the triple question mark. Catastrophe, you're asking the state raise anything regarding the lawyer conduit for Wendy, like Rashbaum was for Donna when Charlie was in the jail. Bridge too far. Well, they're going to call a bunch of lawyers. I'm not sure I quite understand your question, but which lawyer from where? Are you talking about Wendy's lawyer was a conduit? Yeah, I think, for example, the cross-examination of Wendy was totally written out by her lawyer. It's like she knew exactly what he was going to say. That's the way it came across to me. It's very scripted. So when Rajman crossed her, it was totally scripted. I'm sure we're going to do the same kind of thing this trial, whether it's Zellman or Fulford. All those questions will be scripted out ahead of time. There won't be any surprises for Wendy. It's all just really softball type questions that they'll give her. Mina Umit, do I think this time around Georgia Searle will be even harder on Wendy on each trial? They were tougher on her with these questions, especially this last trial with Chara. They were way tougher on her. I think they need to reopen this issue about Wendy's book. I mean, the judge kept the book out and they didn't ask the judge to reopen the book issue. So I'm just, lack of aggressiveness is a real problem I see in trial attorneys. So they should have really gone after that book, explained in detail how the book is relevant to show that this was the hatred of Dan was that extensive and pervasive that it was years before, a couple years before he was murdered, that the book was written, and it made a mockery of Dan. Through symbology, anyway. He obviously wasn't referenced in the book, but when he was taking on the main character, Lily, and Lily's husband was a guy that would, in many ways, mirrored what Wendy thought of Dan. Leslie B, have I ever had a defendant testify and be acquitted? Yes, I have. And numerous times. I would say probably, gosh, I've never kept count, but I would say more times than not, my clients have not testified. I think just one time I can think of a client testified and he was insisting on testifying and he was not, he did not come across well. He was not able to be, he was not very coachable on coming across in a better light. And so I remember that was the one that he got convicted, but it was like it was a minor crime. But it is very high risk. I've said that if you put your client in the stand, it's a high risk game because jurors look at the defendant with a much more critical eye than any other witness. Irene, yes, Wendy and Katie look pretty chummy on the beach photo. Wendy said she only met her twice and never talked to her on the phone. Yeah, why are they so chummy looking? That is true. Molly, they were using WhatsApp to communicate. I think so too, but they never did a subpoena request. Gen exit. Isn't it more likely that Katie was properly advised by her lawyer but refused to comply with her for her own reasons? Okay, yeah. I mean, I'm sure they told her of her options. Hey, do you want to plead guilty and stuff like that? But I'm just telling you, if I know a client is going down, I'm not going to be a part of that train wreck. Okay. If they have a clear, easy path of getting out of jail within days versus going to trial for capital murder or facing life without parole as it was a second time, I'm not going to be a part of that train wreck and help sit there and tell my client, okay, well, that's your option. Do you want to go to trial or not go to trial? No, I'm going to explain to them the consequences and how I'm actually giving them this straight, hard truth now, as opposed to them finding out later that they should have listened to Steinbeck. So I will not let a client make that bad of a decision. I would withdraw from the case. I'm not going to sign up to do something so stupid. And so let a client make that bad decision. If they want to make that bad decision, I cannot imagine why an attorney could not talk them into that. What was Katie's interest in going to trial, especially after Sigfredo got convicted, life without parole? Then you got your two kids there that are not going to have mom or dad. Why would you could go home and see them within days? Why would you not take that deal? I mean, it's just one of the most bizarre things you can ever see in any legal criminal case. Granted, how messed up and ridiculously crazy stupid this murder plot was of the Florida Adelsons. What about the middleman, Katie and Sigfredo, not cutting a deal? This is like so bizarre. The client's making such a bad decision. You better drop the hammer on them and explain to them and be aggressive with them. Tell them what's going on. That's always worked for me. If I've told a client, do you really want to, would you want to face a trial where you're facing life or death penalty and you think you know the law and you can outsmart your lawyer? Do you really want a lawyer defending you that you think you can outsmart and you have zero legal training and you have zero experience going to jury trials? Let's see here, Molly. You're saying, can I do a review of the Jeff Lacasse trilogy of interviews, please? You know, I've never done that. I've talked a lot about Jeff Lacasse being an awesome witness. What a stand-up guy. He saved the day for the prosecution and really showed him what was going on with these Adelsons because he understands the psychology angle and how he was duped. But yeah, I don't know. I don't know if I'll cover him beforehand, before trial. Not planning on it. I'll think about it, but I'm probably not going to do that. Yeah, the TV guy did not die. That was some other guy with the same name. Yeah, why don't they call the TV guy, repair guy who's sitting there for 40 minutes being held up by Wendy over a cracked TV screen? Queen of Hearts. There already is a witness list for both sides. It's not called a witness list, but I've already covered it. JBZ. John will be there most of the entire time. I don't plan on going to the trial. I just plan on going to, right now the plan is to go just to see closing arguments with Leslie. So Leslie and I tend to fly out there to see the closing arguments and leave a couple days later. I just think it's too much to ask to go see a repeat of Charlie's trial for the most part. It's just too frustrating to see all that. It's frustrating for me also to have to see another trial like this. It's mostly Charlie's 2.0. The prosecution did not understand how strong of a case they had against Charlie. That's just mind-boggling. And so if Charlie would have gotten a hung jury, they would have not gone probably a second time, and that'd have been the end of it. No more prosecutions. They were absolutely shocked when they got a conviction. I just don't get that line of thinking. John Smith, I don't think Sigfredo will testify because I don't think he has anything to say that he's going to admit any kind of involvement. The most anticipated testimony will be Donna's eldest son. Cannot wait. I hope they do that. I hope they don't go so light. They don't keep their foot on the gas. Owasso Egan, were they easier on Wendy because of her immunity? You know, that could be some of it. I don't know why they couldn't be tougher. Get her wrapped into some of her lies and impeach her really good. They did some of that last time. Georgia did some of that, but it's one of these deals where if somebody's not coming clean with you and telling you the truth, you gotta go after them. Don't let those lies hang out there for the jury to think that maybe you're okay with, and you think it's credible testimony. If you don't think it's credible testimony as a prosecutor and Wendy's on the stand, go after her on it and impeaching her. Dr. Rob is on the witness list, but we do not know if they'll call him. Just because he's on the witness list doesn't mean they'll call him. So they've not called him to date. I don't know why they wouldn't. Then the year Wendy published her book was a couple years. I think it was 2011. The divorce happened 2013, and the murder happened 2014. Thanks, Lauren. Jillian Roberts, yeah, that's what I've maintained. You're asking, did Charlie and Wendy start dating Jeffrey and Katie at the same time? Was this the long plan? Yeah, absolutely. So Katie was being so-called dating Charlie just to be used as a middleman to find the hitman. And Wendy started dating somebody to turn them into the jilted crazy lover that could be the fall guy for the whole thing. And possibly maybe be another potential source for being a hitman. But boy, did they play that out wrong, as far as Wendy especially. Is anybody going to be at CrimeCon? I really haven't asked that. I've said that Leslie and I are going to CrimeCon for that 5 to 7 time window in Denver. 5 to 7 September. So is anybody going to CrimeCon? And John's going to make it there as well. Yeah, both of them started dating at the same time in the fall of 2013. That is correct. And within 2 weeks of Charlie dating Katie, he asked her, "Hey, do you know anybody that could do some physical hurt on somebody?" And she goes, "Yeah, I know somebody that could do that, take care of that." And that's why he kept on dating her. Yeah, all right. So I'm going to go ahead and sign off for the night. It's after 11 here Central Time. So there's a chance I could be back on Sunday night. Not committing to that just yet, but otherwise, I do plan on covering the trial. I think because of what's going on with Court TV, normally I'd be watching them, but I think I want to do a live stream then covering the entire trial. So that's my current plan then, is to do daily coverage, the live stream coverage of the trial, and do commentary on it then, because I just don't want to see things being misrepresented. So, and that's why I'm not on Court TV anymore. I told Court TV yesterday in an email I don't plan on, I don't wish to take part in any of their channel anymore. Is bad enough the way they had Julie Grant treat Karen Reed, and didn't have any concerns about the railroading and unconstitutional violations on a daily basis going up in that court. So I lost a lot of motivation to take part in the channel. And then what was going on this past week with regard to this supposed plea offer that never existed. So I just don't want to be a part of sort of a clown show like that. Can't take them seriously. If I can't take them seriously, I don't want to waste my time. I was thinking, well, maybe I can be a counterweight to all the craziness going on, but it's too crazy. I don't want to sit there and have to listen to what propaganda is being put out night after night during this trial. So I just need to stay away from that. So yeah, it's more like a tabloid sensationalism than is accurate legal, serious discussion. If it's not serious legal discussion, I don't want to be a part of it. Yeah. So I mean, I was torn being on Court TV. Yeah, Jerry Springer is sort of like the same kind of thing. If you go not only Karen Reed, but now you're going down this case also with your bizarre reporting that's not even accurate reporting. It's just too clickbaity kind of stuff. I just don't want to be a part of that. So enough said. And if I see him at CrimeCon, I'll be happy to ask him, hey, what the heck's going on? Why can't you guys take the law serious? So anyway, you all have a good night. Be safe and have a great weekend. Maybe I'll see you back Sunday night. Thanks for supporting Justice for the Markells. We'll talk to you later. Good night.